All right. Good morning and welcome to the District of Columbia Court of Appeals. We have two matters this morning. I am joined this morning by Associate Judge Beckwith and Senior Judge Washington. We had a minor technical issue, but I think it looks like it's resolved, that all of the names weren't appearing on the screen for those of you who are joining us remotely, but looks like we've resolved that. First case is Joseph Minor versus United States. Counsel, are you ready to proceed?
May it please the court. Cody Akins for appellant Joseph Minor. I'd like to please reserve 3 minutes for rebuttal.
Right.
I'd like to focus my time this morning on the issue presented in Mr. Minor's appeal from the denial of his 23-110 motion. Unless the court has questions, I'll rest on my briefing on the direct appeal issues. The case against Joseph Minor was weak. There was no forensic evidence linking him to the crime, no DNA, no fingerprints, no ballistics, nothing. The only motive evidence was offered by 2 non-credible witnesses. And of the 16 witnesses the government called, just 2 offered any evidence linking Mr. Minor to the crime: Alan Culver and Devon Hungerford. Culver was a 6-time jailhouse informant facing a 40-year sentence for his own murder charge. And he admitted that in exchange for testifying against Mr. Minor, he hoped to receive leniency on his sentence and maybe even a new Camaro from the government.
Counsel, I know you didn't want to focus much on the direct appeal, but since you bring up Mr. Culver, he did have some impediments or disabilities perhaps with his testimony, but his testimony was borne out by a lot of other evidence or bolstered or verified in many ways by other evidence in the record. And the other witness, Tank, you say it was weak, but his testimony also seems to be unrefuted. I know you had some challenges to the identification, which brings us to your 23-110 argument. So,
yes, Your Honor. Let me start with Mr. Culver, and then I'll turn to Mr. Hungerford. Starting with Mr. Culver, I think you're right that much of his testimony was corroborated by some of the evidence at the scene. I think that's explainable, or at least the jury could have thought that that was explainable, because it's undisputed that Mr. Culver also spoke to Blakey, the other co-defendant, who admitted that he was at the scene, admitted the crime, pled guilty. And so it's very plausible that Mr. Culver got those details from Blakey and not from Minor. And one of the reasons we know that that might be the case is actually that Culver messed up some of the details that he would have only been able to get from Mr. Minor. So Mr. Culver testified that Minor told him that the gun used in the shooting was disassembled and hidden in the shoes at some shoes at his girlfriend's apartment. That was wrong. The police searched the apartment, found no gun. So the details that he could have gotten from Minor, he didn't get right.
Does that necessarily mean it was wrong, or just that it had changed?
That's certainly plausible. My point is only that, the only details that he necessarily got right are also the ones that he could have gotten from Blakey. And again, at least the jury could have thought that. And turning to Mr. Hungerford, again, it's true that much of the evidence corroborated his story, but our point is not that he was lying. It was simply that he was mistaken about the identification of Mr. Minor. And in this court's decision in Jones, there was also corroborating evidence of the eyewitness. There were crime scene photos that matched his description of the events.
Jones wasn't a familiar identification. It was a stranger identification. And I think that seems to be, in my mind, an important distinction. That Tank, or I'm sorry, Mr. Hungerford, there were a lot of nicknames in this case. Mr. Hungerford never claimed to have seen the faces clearly, but that wasn't the basis of the identification. The basis of his identification was, I know these guys, for over a decade, I believe he said. We grew up together. I recognize the voices. I recognize the gait. I recognize, why isn't that enough to make him a credible witness?
So 2 points on that. The first one is that, I don't think there's any reason legally that this court's opinion in Jones should be limited to stranger identifications. The expert record in this case showed that the same kind of psychological features.
Expert record, you're talking about at the hearing on the 23-110.
That's right, Your Honor. That's right.
At the trial, there was no record, right? Because nobody offered anything. And so at the 23-110, the testimony that was offered, the trial court listened to, evaluated, and determined was not a science that was well accepted within the relevant scientific community. It's an opinion, but it has to meet certain standards in order to be admissible, correct?
Certainly, Your Honor.
And so you offered it, and sure, if we look at it and we don't evaluate it in terms of expert opinion admissibility, sure, it could aid, but why is it beyond, I mean, you could argue that it aided, but the court was looking at it saying, would this evidence be admissible in a trial court? And they said there is no general agreement within the scientific community and whatever the other now legal standards are for admissibility under 4.2 and 7.3 of this type of evidence. So, and I'm trying to figure out why the trial court is wrong when the science relied on, one, the expert was a stranger ID expert, and two, the overwhelming majority of the cases and the studies that she relied on, I mean, overwhelming, like 40-something to 3, point to significant distinctions between the two. And why, I'm sorry to throw the third question in there, when you have the involvement, engagement of these parties that you've had decades of relationships, recognizing their friends by many measures other than face, why any of that would be relevant? Because a jury certainly could evaluate whether they know what their friends look like in the dark through an alley at 50 feet that they've been associated with for many, many years.
Let me, I think, try to take those in a few different pieces here, Judge Washington.
And I apologize.
No, I'm happy to answer. Let me start with the kind of the science piece, the state of the research. I think to the extent that the Superior Court was looking for general acceptance of these principles, he was ultimately looking for the wrong thing. When this court transitioned from the Dias-Frye test to the Motorola test, it was very clear that general acceptance of the scientific principle is no longer required. What's required is reliability of the principle. And what Dr. Covera explained at the evidentiary hearing was that many of the principles that are applicable in the stranger identification context are equally or more applicable in the familiar identification context. She said things like, if you can't see the face, it doesn't matter whether they're familiar. Or the fact that someone is familiar to you could actually be a problem because you kind of gap fill when you can't see a face. You see someone you might expect to see instead of who is actually there. So she was taking principles that were established in the stranger identification context and showing why they could be reliably applied in the familiar identification context. And that is all the Motorola test requires.
Can I just interrupt you on that? Are we, from your perspective, are we required in deciding this ineffectiveness claim to decide as a threshold matter whether the trial judge was wrong in giving his opinion that this particular expert evidence would not meet the standards? It's like, is that like a threshold legal question?
It's a great question, Judge Beckwith, and it's right where I was going next, which is kind of the standard of review that we're looking at this through. This is not an abuse of discretion admissibility ruling. We are not here on a direct appeal from a trial judge's evidentiary ruling that takes into account the kind of trial management evidentiary concerns that come up on direct appeal. The question, as this court emphasized in Jones, it emphasized it in Kigosi, is that whether there is a reasonable probability of a different result. Of course, admissibility is a subcomponent of that. But the ultimate question is not, did the district court here abuse its discretion, but rather whether there's a reasonable probability that this expert testimony or testimony like it would have been admitted at trial. That's a lower bar, and we think it's one that we easily clear.
Don't we also have to consider, since this is unpreserved error, the burden was on Mr. Minor in the 23-110 hearing to show that his counsel was deficient by not proffering or failing to consider whether to proffer an expert witness. And what we don't know here is that we don't know whether counsel considered proffering an expert and decided no. That might not help here, given, as Washington says, maybe reasonable jurors could infer that it was possible to identify this person. Or counsel may have had other strategic reasons for considering and not proffering an expert. We don't know that because counsel wasn't there. And counsel wasn't there because Mr. Minor didn't cause him to be there. How does that weigh in our evaluation at this point? It seems a bit unusual where there's an ineffective claim, a hearing is granted, and then the key witness, the counsel in many ways, doesn't show up. How do we weigh that in terms of what our standard should be here on an unpreserved error like this?
So 2 points on that, Madam Chief Judge. The first is that we don't understand this court's case law or really any federal case law to require the testimony of trial counsel in order to make out a claim of ineffective assistance of counsel. The Supreme Court in the Buck v. Davis case that we cited in our brief found ineffective assistance without the testimony of trial counsel there.
Well, here there's a key question though, which is my question about, I thought part of the standard is whether counsel considered and then determined whether or not to call an expert witness.
It is, and we are not shying away from the fact that that is our burden. However, this court's been clear in the pretrial ineffective assistance of counsel line of cases that trial counsel's actual performance at trial is fair game. That's circumstantial evidence of counsel's preparedness for the trial itself. So we think here, trial counsel's actual performance at trial should give the court some.
I'm sorry to interrupt you again, but you led me to another one of my questions. Here in your brief, Mr. Minor mentions lots of potential deficient performance examples of counsel, but doesn't rely on those as part of this ineffective assistance of counsel claim. So it's sort of like atmospherics. What are we supposed to do with that when the claim ineffective assistance of counsel doesn't rely on those other issues?
We don't read this court's cases. You said the Portillo case in our brief. There's others that cite the same principle to require that you kind of bring all of counsel's deficiencies in order for those to be fair game as circumstantial evidence of what trial counsel actually did. So we're only relying on those as kind of evidence of trial counsel's unpreparedness. But even if you disagree with me on that, suppose we assume for sake of argument the trial counsel did actually explore calling an expert witness. Then the next question is, did he have a reasonable justification for not going on to actually try to call that witness? And here, we don't think either the government or the superior court have been able to offer a single plausible explanation for why he wouldn't have done that.
But doesn't the superior court do that when it says this witness, Dr. Covera, is maybe qualified for some purposes, but is not qualified for the purpose that Mr. Minor's alleging the witness would have been qualified for? So how does that support your argument here?
So I think what the superior court was getting at was that that trial counsel could have thought that there would be some contest over the admissibility. Of course there would be. Of course the government wouldn't want this evidence in. That doesn't excuse trial counsel from the obligation of trying. It's not like it would have been frivolous to try and get this kind of evidence in. And
Well, there was a lot of support in our case law for admitting this type of evidence. I mean, you're looking at a level of competence where what does a competent attorney do when there's no support in the case law, that no other courts have introduced similar evidence and had it ruled upon as admissible or not, and you have somebody who you're representing who the witnesses against are people that have known them over a decade. Why would it jump to your mind that somehow you're deficient for not finding the one person who might take some principles and get to a result that is supportive of your client's innocence?
So I don't actually read the case law maybe quite as bad as you do, Judge Washington. Let me try to convince you of that.
Well, I'm just asking questions. I didn't say that's how I read the case law, but
I
Go
understand,
ahead.
Your Honor. So I would start with, trial counsel would have been aware of the Ben case from 2009, which, kind of broke some ground in saying that this kind of evidence is useful. I spot you that was in a stranger identification case. But then you go to the Heath case in 2011. This court is very clear over what I thought was a persuasive dissent by the now Chief Judge, that in that case, that evidence from an expert witness on eyewitness identification should have been admitted in a familiar identification case. And this court said in footnote 53, we're absolutely not drawing a bright line that says that this kind of evidence is never admissible. I think you take those things together and reasonable trial counsel says, look, my only line of defense, he says this in closing, my line of defense is that Hungerford was mistaken. If that is your only line of defense, what is the justification for not trying to go the step further?
Arc, distance, there's a lot of evidence in the case from which a reasonable juror could have disagreed with his or could have found his identification to be suspect, right?
I mean, I think that that's true, but it was also true in the Jones case.
We're talking about I guess this is a 23-110. We're talking about deficiency, right, of counsel. We're not talking about perfect trials. We're not talking about a circumstance where if I don't do everything that could have been done, I don't go the extra mile and find that the footnote 56 could have related to this, and therefore I'm a deficient counsel. We'd have a lot of deficient counsel out there if they didn't have the resources or the wherewithal to read that as perhaps allowing this to go forward. And maybe you're right. Maybe there should have been at least an effort if you thought of it. But really, is that the standard? What is the standard that we're supposed to be looking at to determine deficiency, going back to the chief's initial point of nobody called him, so we don't really know what he was thinking. But what does the law say about deficiency?
I see that I'm out of time. May I respond, Your Honor?
Yes.
I think that this court's case law in Jones was clear that when a case hinges primarily on an eyewitness expert, trial counsel has a professional obligation to explore considering an eyewitness expert. We're not saying that he has to do everything possible, everything under the sun. What we're saying is when the case, this is the government's central evidence, and your only line of defense is misidentification, that you should do more than just cross-examine. I think Jones stands for that principle, and that there's no reason to limit Jones to stranger identifications.
Can I ask you one more question along these lines? The missing trial counsel is unusual, but are you now saying, there's this focus on what is the evidence that counsel failed to consider calling a witness? Are you now saying that that's not really the question? The question is, it's more like the record speaks for itself, whether whatever he would have said on the stand wouldn't have changed what the ruling should be on deficiency. I'm sort of interested in this affidavit question. Like could the affidavit of your client serve as evidence that judge kind of rejected it on hearsay grounds or something? Do you need that to get to the explanation of why, that he did not really consider it? Or are you now saying, I thought I heard you sort of saying things like, just look at this record and anyone would have called that?
2 points on that. We're fine, setting the affidavit to the side. We agree with the Superior Court that really at most what that showed was that trial counsel, assuming it's admissible, trial counsel did not talk to his client about this, which I agree is not proof positive that he did not in fact explore. So we're fine setting that to the side. We think, to your point, that the trial record essentially speaks for itself, that this court can infer based on the many, many mistakes, obvious mistakes that trial counsel made. For example, he promised the jury to give an opening statement and then didn't. That really hurt credibility.
But that's the kind of thing, if he had showed up and testified, he might have said, I think every lawyer should probably make an opening statement, but I could imagine him saying, in this kind of case, there was, or some other trial lawyer in another case saying, I don't know where the government's going, so I'm going to reserve my statement, or I'm not going to make one because it can only, I might get caught not being able to prove or deciding not to prove what I promised. He might have said something like that. I sort of, see your point about it speaking for itself on the familiarity, the ID issues, but on some of the other issues, I'm not so sure.
So I'll just say he did reserve. I think he probably wisely reserved, but then didn't do anything.
Yeah.
So he says, I'm going to make an opening statement later.
Yeah.
And then just doesn't. It's only one example of some of the mistakes that he made. But our point, yes, is essentially that you can, rest on the record as exists for the exploration point. But then alternatively, even if you think he did explore, that the failure to call was itself unjustifiable.
That's one more question.
Yeah, go ahead.
We're over time, but we've got some more questions, so.
Happy to stay up here.
No, it's, if I recall correctly, because you keep going to the Jones and citing the Jones case, which was a stranger ID case.
Yes, Your Honor.
Pure. The trial court and presumably reading a lot of our other cases seem to say, well, why isn't this more like Heath? Regardless of whether it's Jones or, I mean, to your point, if a lawyer, defense lawyer is looking at our case law and sees Heath, which is a case in which we said, well, this is irrelevant because this is not a stranger identification, and Jones, in which it was a stranger identification, but as you suggest in a footnote, we hold out, not part of the holding, that perhaps it could be under certain circumstances, this evidence admissible. Again, I'm questioning, how do we decide in one case it's deficient performance if it's later challenged, and in another case, when they're citing our case law to us, find that it's not deficient?
I think
Let me ask you, if the trial lawyer had appeared and said, I looked at the case law. The case law seemed to be universally supportive of the idea that such evidence would not be admissible in a non-stranger ID. And you made all the same arguments about how, well, darkness and, could have been wrong, and certainly it would have been a good defense. Would that have amounted to a deficiency by the trial lawyer?
I think it would, Your Honor. The Strickland is clear. This court has been clear. Strickland deficiency is an objective test. So the fact that trial counsel comes in and says, I read the cases this way, and so I thought it was reasonable, the court shouldn't concern itself with that. The question is, objectively reading the cases, could reasonable trial counsel have thought that this was an important enough step in the defense that it required investigation and then calling the expert? And we think that it certainly could have. Heath, again, is very clear that it is not excluding this type of evidence categorically. And then you go on in the court's cases and it shows some openness to it. And then you talk to an expert and they say, actually, a lot of the stranger identification principles can equally be applied in the familiar identification context, as Dr. Covera explained here.
Can I just ask one question? I know you wanted to focus on the 23-110, but I do just have one question about the hearsay claim you raised on the direct appeal issue. And that is, you conceded that it was plain error and that it wasn't objected to, but can you explain, there's the discussion following the point at which the testimony in question comes in, where there is a request by the government to put in something that seems like it might be the same thing, and then there is an objection to it, and the judge says that's not admissible. You didn't argue that constituted an adequate objection. What's going on there?
I, to be honest, kind of share your confusion about what's going on.
And the judge herself said, this is very confusing what's happening. So
precisely. So we didn't think that there was certainly a clear enough objection to preserve, is why we didn't argue that candidly. So it's a little confusing. I understood that part of the transcript, that the part that Mr. Nichols was objecting to was a different part of the testimony, not the part of the testimony that we're talking about in the hearsay objection, particularly the statement, Minor told me, or excuse me, Lee told me that it was Minor that he had this altercation with. Thank you.
Thank you, and we'll reserve your time for rebuttal.
Good morning, Your Honors. May it please the court, Michael McGovern on behalf of Appellee of the United States. Dealing with the ineffective assistance of counsel claim, fundamentally, regardless of what theory of deficiency, and I think there are sort of two different types of deficient performance ways that one could go about the claims being raised. The specific claim they raised below was that there had been no exploration of this. We, of course, have countered that we don't believe the record supports finding that, but there's also an analysis by the trial court of the idea that an objective defense counsel would have found an expert and presented that testimony. Regardless of which theory of deficiency you choose, there are two fundamental findings that still need to be made before there can be an ineffective assistance of counsel meritorious claim. And that is first, that any expert testimony that was found would be admissible, and also that had it been admitted at trial, there would have been prejudice. In other words, a likelihood of a reasonable probability of a different result. And on this record, appellant has failed to establish either of those precursors. So whether you lump them into a deficiency analysis or a prejudice analysis, they have failed to make those showings. And that is because, as counsel represented to this court just a minute ago, the fundamental basis of Dr. Covera's report is that one can interpolate the findings regarding reliability of stranger identification science into familiar identification science.
I know-
And this,
I'm sorry to interrupt you on this point, because I know we asked a lot of questions about that issue and whether or not the testimony of an expert like Dr. Covera is fungible regardless of what kind of witness identification is involved. Let's go to the facts of the Jones case, which appellant relies heavily on. And the court seemed, I guess one could argue that the court seemed focused there primarily on the fact that there was a single witness that seemed to be the focus of the government's case. And we have that here. If we set aside Mr. Allen, I forgot his last name at the moment.
Mr. Culver.
The jailhouse snitches testimony, as some have characterized it. Mr. Hungerford Tank is really the source and strength of the government's case. It rises or falls on his testimony. And Jones seems to support the proposition that when you have a witness that's so central to the government's defense, yes, you should call an expert to help with the identification there.
So I agree with that characterization of Jones, that it says when you have what is essentially a central identification at issue, and it was looking specifically at a stranger identification case, and I think that's important, and I'll return to why, then it is deficient performance to fail to consider calling an expert.
Do we have any experts on familiar?
Well,
Or any cases that talk about experts?
We do, and that's Parker, and I think that this case fits much more into the Parker line. But I think what's important from Jones is specifically in the deficiency, in determining that it would be a deficient performance in order to fail to consider calling an expert, this court specifically turned and said, we have recognized the state of social science research with respect to the reliability of eyewitness testimony has progressed to widespread acceptance among experts. And then it turned to court decisions and said, courts routinely allow this type of identification evidence in. That was a part of its deficiency holding. We're on different ground here, both in the legal realm that applies to stranger identifications and the scientific realm of what applies.
On the legal ground, what's your response to your opponent's comment about Heath saying it's not categorically excluded?
Heath said it was not categorically excluded, but you have Parker, which says that an expert who is relying primarily on stranger identification evidence or studies in order to proffer an opinion on a familiar identification may be excluded because it is not helpful under Rule 702. Now, there is a procedural twist. It was originally decided under Dias, and so it was a harmless error analysis. But what the court essentially said is under 702A helpfulness, an expert who is relying, whose testimony and opinion is centered on stranger identification social science can be excluded and would be excluded. And that's in 2021.
Wouldn't it depend a lot on the facts of the case, and why does there have to be such a bright line between familiar and, we're acting like they're two completely different things where, here we all have had this experience of thinking we see someone we know and realizing later it's not. And the fact that Mr. Hungerford knows Mr. Minor, it's Hungerford, right? it doesn't necessarily mean that every time he thinks he sees him, he is seeing him.
That's correct.
Yeah,
To the extent that it is within the ken of the jurors to understand that concept, an expert witness isn't necessary. And in fact, there is a danger here, which I think is explained in the 403 analysis that the motions court did below in this case, which is when you start to apply some of the social science research on stranger identification in the familiar context, you may actually be overstating the dangers of the familiar identification. And the fact is the social science on familiar identification doesn't exist. And this is something that Dr. Covera herself recognized.
there were
are not
studies, right?
there was one. So there was one study that actually had to do with estimator variables, and the only estimator variables it was looking at were light and distance, and that study specifically found that familiar identifications were more reliable. They resulted in correct identifications more frequently, and it specifically said this study should not be used in situations where the familiar identification is also based on information other than the face. So the
Does this mean
2000
that an expert has nothing, an expert in eyewitness, ID has nothing to say that would be useful to a jury, like about, perception and dark and conditions and weapons focus and stress.
if there were any studies that showed that weapons focus and stress had the same effects in the context of familiar, fine, but Dr. Covera specifically testified, and this is on page 193 of the hearing, there are no studies on the effect of stress on familiar identification. There are no studies on weapons focus on familiar identifications. There are no studies on the effect of multiple perpetrators on studies on familiar
I guess I was
identifications.
thinking when we know that he isn't talking about seeing the face, right? So it seems like some of these things might apply to everyone,
But
familiar or not, you know what I mean?
There has to be so 702 requires that there be not only reliable science, and we're not challenging the reliability of the stranger studies that Dr. Covera, and we didn't even challenge that Dr. Covera is an expert in those studies. But 702D requires that reliable science be reliably applied. And here, there are multiple studies on which Dr. Covera relies, which specifically distinguish the cognitive functions that are occurring when a stranger identification is being made versus when a familiar identification is being made. So there are studies that say different cognitive processes are at play. And we have no studies that show us what the rates of potential issues may be with respect to weapons or stress. And to the extent that we have a study, the 2005 De Jong study on lighting and distance, what that study says is, yes, in fact, people more frequently correctly identify people when they are familiar with them. And you should not use this study, the only familiar study that involved estimator variables, should not use this study when there were other features other than the face that they could be concentrated on, because people may be able to identify by that. So the state of the science, as Dr. Covera even says, is that we just don't know about these effects with familiar identification. What we do know is that familiar identification is in some way different than stranger identification. And we don't have any empirical research, or Dr. Covera presents no empirical research about what that is. And so her statement, you should interpolate these concepts from stranger identification into familiar identification, is based purely on her say-so as an expert. And that is not sufficient under 702D. It just simply isn't. She needs to show that she reliably applied these sciences. Not only did the science not support her, but her application of those studies, the trial court found, was suspect here. That was because she included a sort of misleading chart of how often identifications are correct versus familiar and stranger in her report. She ended up ignoring some of the statements, like in the De Jong statement that says you shouldn't use this study, or our findings are not applicable where there are more ways in which to view someone. She constantly shifted her description of how well-known Hungerford was to Minor, or how well-known Minor was to Hungerford. She at first in relying on a study which had a very specific definition of what it meant to be a casual acquaintance or to be casually known to someone, she first said there is no definition of casual. And then when she was presented with that definition, she adopted that definition onto what she believed to be the relationship between Minor and Hungerford. So there simply isn't any reliable support for the positions that Dr. Covera was announcing.
So how do you fit these conclusions or parts of her testimony to the trial judge for us in terms of the lens we should be looking at this?
Yes.
In an unpreserved, plain error case? Is all of this to say that therefore what, even if the evidence was properly excluded, would have been excluded?
The evidence would have properly been excluded, and therefore, well, ultimately that absolutely means there was no prejudice. That could be the end. You don't need to address deficiency if you find no prejudice. You could include it under a deficiency analysis, and I can go into sort of structurally how you could view this.
Does that go to some of the other atmospherics related to Mr. Nichols' performance at trial, when you say you could include it in a?
Well, so as I sort of began with, I think there are two different theories of deficiency that this case could be viewed under, two different lenses. One is he did not ever consider calling an identification expert. And that is more akin to Jones. That is what Jones said, right? We had an actual counsel who said, I did not consider calling an expert. But in order to factually, right, the burden in an ineffective assistance of counsel claim lies with the appellant or lies with the defendant below, and they must show by a preponderance of the evidence that counsel was deficient. So to succeed on a theory that he did not even consider calling an expert eyewitness, he needs to provide some record that shows by a preponderance, right, that it is more likely than not that this counsel never did. And our view is that, as the motions court found below, without any testimony from defense counsel to say, I didn't consider that.
Is there no value to the affidavit? You think it's not admissible?
I agree with opposing counsel where he said the value was very slight, if any, that it certainly stood, so, excuse me. I'll first start with, I don't think that the trial court was erred by failing to consider the affidavit because it was hearsay, and this court has said that in 23-110 hearings, a court may apply the rules of evidence. And so because Minor chose not to take the stand and testify and wasn't subject to the crucible of cross-examination, that should be out. And the trial court was not erroneous for doing so. But the trial court didn't stop there. The trial court actually said, even if I were to consider it, the probative value, and this is what opposing counsel recognized himself, the probative value is very slight. He simply said he never discussed it with me.
So that sounds ineffective in itself if he's not talking to his client about, you know, if he actually was thinking about calling a witness. And I mean, this isn't the claim that's raised, but I'm just not sure how probative that is. That he wouldn't talk to his client about the witnesses he's thinking of calling?
So the claim hasn't been presented that way to this court. And what I will note is I haven't been able to think through if one were to consider, right, if I sit at my desk and consider, should I call an identification expert, and then think, you know what? I've seen cases in which the court has said familiar identifications are different. When we look at reliability analyses in motions to suppress identifications, we usually let them bring in a confirmation ID because we believe as a legal matter it's more reliable when someone has familiarity with them. I'm looking at the facts of this case and it just simply says to me that he was familiar with him, and I don't think that there's going to be a good basis. I also haven't seen any scientific studies that would even support that. The science isn't there. If someone were sitting at their desk, went through that mental analysis and said, I don't think it's worth my time to even try to present this to someone. I'd have to ask the court to give me a voucher, and then I'd have to talk to someone and explain the case to them. I don't know that it would be ineffective to not tell your client, this is what I was thinking at my desk for 45 minutes as I considered this case, when you come to the conclusion that in fact it wouldn't. So I don't have a good answer, but that's where I sort of find myself analytically on that question. So to show that he didn't even consider it, again, the claim that was in Jones, he needed to have some evidence that there was no consideration, and that simply is not in the record. And we don't dispute that trial performance could be some type of circumstantial evidence, but when you put that against the state of the law, as Judge Washington has been discussing, and the state of the science, which I've been discussing in my argument, I don't know that just the way, I don't believe the trial court erred when it found that it couldn't say it was more likely than not that he never even considered it. So on that deficiency theory, I think the trial court was very within its, did not err
Can you
when it
clarify?
decided he wasn't deficient for not considering.
Can you clarify the record about what was the government was trying to obtain trial counsel's presence at the hearing and was unsuccessful, or what was going on there?
So my reading of the record is that government counsel was seeking to try to bring to subpoena the defense counsel. It appeared the defense counsel was not wanting to speak with the government and ultimately said, well, we're not going to call him. There certainly, had we wanted to proceed on a theory that defense counsel had strategically done this, if that were our theory, was no, this was a strategic decision, there would need to be some type of evidence that it was a strategic decision. So it was possible that had the government spoken to him and been able to determine that in fact it was a strategic decision, they may wish to call him. When he was dodging the government ultimately said no and said, but we are going to rely on the burden of the ineffective assistance of counsel claim, and the person who bears that burden is the defendant. And defendant has the obligation to show that he didn't even consider it. And on this record, we don't believe, and the trial court agreed, we don't believe that they can show that. Again, there would then be the theory of deficiency, which was not really teed up below, but has been sort of advanced in this court and was, I believe, the subject of the analysis of the trial court's opinion below. And that is that there was deficient performance because they simply failed to admit this testimony, right? Regardless of whether he considered it or not, any counsel would have admitted it. But even on that, the deficiency inquiry goes back to those sort of two fundamental questions that I was asking at the beginning. Would it be admissible? No, we don't believe that it would be. And even if it were admissible, would it be prejudicial? There's an additional twist here, which would a reasonable counsel think, even if it's admissible, there are some real dangers to me presenting an expert like Dr. Covera.
Is that strategic?
I think an objective counsel would be able to look at that. And I think when one looks at the actual testimony that came out and the manner in which it came out, it doesn't paint a good picture of the expert's opinion. And there is a danger, I think an objective counsel could look at whether or not the manner in which this came out would potentially be damaging, could have a negative effect on a jury who says, I really think that you're really stretching here, and that somehow seems like it's indicative of consciousness of guilt. So there could be very good reasons not to present very weak expert opinion where your expert would be subject to.
But again, you didn't call, or the government didn't get that out of the trial counsel.
No, but there is now a record of what the cross-examination of this expert would have looked like. And I think that the court can properly look to that record and say an objective counsel faced with what this cross-examination would have looked like would have said, there's no way that I am calling Dr. Covera in this case. It's going to do nothing but harm me. Regardless of the theory of deficient performance, and I do realize that I'm very much over my time, but I would like to touch on prejudice, especially because there were a few questions about Culver and Hungerford at the very beginning. So I just like to briefly touch on that if the court permits. And that would be, with respect to prejudice analysis, the case here was very strong. We don't just have Hungerford's identification, but we have corroborative evidence We have physical evidence that corroborates that Hungerford was a reliable recounter of his narrative, right? The physical evidence corroborated his entire narrative
Only
of
get
that
you
evening.
so far to, you know, his ID being good, like that he said he left the cup on top of the car and there was a cup on top of a car doesn't necessarily mean, oh, he knew who he was looking at in the dark from 50 feet away without seeing his face.
Certainly, again,
yeah.
I think it's corroborative that he is a reliable witness, that he is testifying as to what his memory is, and that matches, which also indicates that he firmly believes.
I'm interested in Culver, who, you know, is a very, what he says is very strong for the government, but he's also, you know, very impeached and a very flawed witness with a lot of reason to say what the government wants him to say. But what about your opponent's point about, I'm interested in your view of the aspects of Culver's testimony and the extent to which he couldn't have known that except from Minor and, you know, instead of Blakey.
So my understanding is that the only testimony Culver had about his interaction with Blakey is that they were briefly in a holding cell together while one was being transferred from.
That's all that would be needed for him to learn things from him, right?
Perhaps. I think the extent of the knowledge was more than that. I mean, that in what appears to be a very limited period of time, he had lots of factual information. But I would also say that there was a
girlfriend's, phone call. You have Minor's phone call to Alan's girlfriend,
correct.
where she seems to be saying that Alan was talking to Mo, or Mo was talking to Alan, and could have learned some things that then Alan tries to recount as part of his testimony.
So I think Alan Culver, I think what's important about that phone call is that Minor says there are only a few people that could have known this information, and Alan is one of those people. So Minor is
Mo's the other
specifically,
one.
I'm sorry?
Mo is the other one.
We know that Minor and Culver are sharing a cell for an extended period of time. I think that the probative weight of believing that this information all came from Mo Blakey, who at this point, it is not nearly as powerful as the fact that they were in the cell together for an extended period of time, the fact that Minor admitted that he knew that that Alan had information about this. And I think what's important there too is that regardless of whom he's receiving this information from, he's receiving information that it's Minor and Blakey, right? That it's not just Blakey, he's putting Minor there as well in whatever this story is. So, and they were sort of confederates in this. So to the extent you attribute it to Blakey, it's really sort of a co-conspirator admission as well. I don't know that probatively that gets us anywhere to say this came from Blakey, not Minor. There is certainly he was impeached with the benefits that he was anticipating to receive from the government, but it was also a fact that if he was found committing perjury on the stand, that all of those benefits would be revoked and he would suffer some consequences in his own case. So yes, he was certainly not a perfect witness. We're not holding him out to that, but it was corroborative. Additionally, he had information that Tweety had driven with them there. And when you see the phone call with Tweety, when she tells Minor that she was subpoenaed to the grand jury, he tells her to be quiet. There's clearly a concern on his part that she's going to reveal some type of information. Culver is the source of information to say Tweety was in it. She was one of the people that was in that car. She had information. There was a reason for Minor to be concerned, and that concern is borne out by the jail calls as well. So there was corroborating information there as well. So this was a very strong case. They knew each other very well.
Can I ask one question, and I'll ask of opposing counsel too, because we didn't cover it on direct. But is there anything else you wanted to say about the government's aiding and abetting theory?
I'm happy to answer any questions the court may have about the aiding and abetting. We believe that as a legal proposition, it's appropriate to consider it under the PFCV charge.
I just have, I'd love to get your view of the, on the hearsay question.
Yes.
I sort of got the impression in the way the government's brief was written that you almost were more aware of or more concerned about the possible preservation of this issue, notwithstanding the concession. But, what's going on in that conversation among the parties and the judge after the hearsay that we're concerned about comes in?
So, Your Honor, I think the record is certainly not a model of clarity, and Your Honors have the same information that I have, which is essentially from pages 106 to 112 of the transcript where this actually comes out. My understanding is that the government's theory was that, and this is taken from different parts of the record, Minor and Lee had an argument in which Minor had taken a coat from him and Lee had taken the coat back from Minor. After this, there had been gunshots that Minor fired at Lee. So I believe that this is, right, this is what we hear about this from Mo Blakey's stepfather when he says, I saw Lee taking the jacket back from Minor. We also hear from Culver about an attempted robbery that didn't work, but that resulted in Minor firing bullets at Lee. During the questioning of Hungerford, the government indicates it believes that incident in which there had been a struggle, I'll call it a struggle over the coat, but there had been sort of the takings of the coat and then guns fired, that directly after that incident, Lee went to Hungerford and was in an emotional state and told him about what had happened. So that was what I understand to be the bad interaction. And so the government's theory was that he was worked up, and they begin this questioning on page 106 by attempting, it seems to me as I read it, to establish the basis of excited utterance. They ask him, what was his state, right? Was there a bad interaction? Don't tell me anything about what he said. I want to know, was there a bad interaction? How was he responding to that bad interaction? When did he tell you about it? I think right after. Now, admittedly, does not get a lot of information from Hungerford and moves on because there is another interaction for which Hungerford was present.
But wait, are you talking about now are you about to talk about the 107 or you're going forward?
So that was 106 to 107.
Oh, but at 107, you sort of skip the part where he says, who did he say the bad interaction was with? And he answers that.
Correct.
Okay.
Correct. And that is the alleged hearsay.
Right.
And certainly
You're sort of conceding that they didn't get a lot on the excited utterance at that point.
at that point, I don't believe that if this were a preserved error, that we would be arguing that we satisfied excited utterance. But I do wish, just for context, to say I believe that the questioning was trying to build that theory of the case. So when he's not receiving sort of very much, and he does get information, which is challenged as hearsay, and we admit has to be subject to a hearsay exception, he moves on to a different interaction, which is not hearsay, in which Hungerford witnesses an interaction between Minor and Lee. During this interaction, the government, as its proffer indicates, knows that Hungerford was concerned about that interaction because there seemed to be some type of aggression going on at that time. So it attempts to elicit this. Hungerford's testimony, again, is not particularly helpful on this issue. So the prosecutor then tries to impeach him and says, when I spoke to you, didn't you tell me that there was some type of aggression? And he says, yes, I did say that to you, right? So we know that he witnessed this. Then the government turns back to the original interaction and says, Your Honor, in light of that, I would like to ask him specifics about the first interaction because I believe those would inform why he was concerned about the violence or the aggression that he's seen on the second occasion. The court basically says, this is all very confusing. I can't fault the court for that finding. This is all very confusing. It's unclear to me who's taking the coat. What are you trying to get this in for? But what this record, I believe, when read in context shows, is that the government at that point was seeking to elicit the rest of the hearsay statements, recognizing they were hearsay, under present sense impression, or under state of mind exception, to show why it was that Hungerford had been concerned about the aggression that he had seen in the second incident. He also then says, this is the prosecutor, and I'm on page 111. When the court says that's hearsay, the prosecutor says, he said that it was right after the incident that Sweet Pea was upset and came and described it to him. Again, the prosecutor is referencing the contours of excited utterance here. The court immediately doesn't seem to take that as an excited utterance proffer, but instead says that's not a present sense impression, which is correct, right? Timing wise, it couldn't be, and says it might explain why he's upset, giving some credence to the effect on listener. But it's not really a present sense impression. I don't think you can get into this, and the government drops it. And I think that's because what is most important here, that's why we believe we're on plain error, is, well, there's a concession that we're on plain error. But that's how we get to the fact that we believe that there was, in the record, some indication that there were exceptions the government was seeking to use to get this in. And this record doesn't fully belie those. As I said to you, I don't believe that the record establishes those, but we're on plain error review, and so it has to be plain.
But is it arguable that, I mean, setting the concession aside, which I'm not saying we would do that, but just for my own understanding of this issue, is it arguable that when considering the purposes of the preservation rule, this was hashed out here, the judge ruled on it, there's an objection about basically the same thing.
I don't believe so, because
yeah.
the government really abandons, like, I don't believe that that was fully teed up, because what you see is the government saying it goes to the effect on Hungerford. It also seems to be when he's excited and upset, and the court says, but that's not a present sense impression, which was not even the word that the government, so I don't think.
Yeah, you make the point in your brief that defense didn't ask to go back and strike the thing before. It seems like they just didn't hear it, or, you know, people weren't, I'm not sure.
And all of this, regardless of whether, even if we were on sort of direct route, right, de novo review, we would be making a harmlessness argument, just as we made our no prejudice argument here, which is this testimony, as confused as it was when it came in and as innocuous as it was, right, there was a bad interaction, was not the testimony on which the government was relying for its motive theory of the case.
Was that skewed in the closing argument?
No.
Okay.
So in closing argument for motive, we relied on Culver and the stepfather of Mo Blakely.
What was the statement? We're talking about who did he say the bad interaction was with, to which Mr. Hungerford indicated such interactions were with Mo, that there had been two such interactions, one with Mo and the other with Chuck. What was the purpose of that statement? Was it hearsay? Did it fall within an exception, or was it non-hearsay?
So we believe that it would be hearsay that would need to, right, the only way that he knows that the bad interaction was with Mo and Chuck is through the statement of Lee. So it would be hearsay. But we believe that the government, the record indicates, can be read to show that the government was trying to lay the foundation for two different hearsay exceptions that could have applied, ultimately abandoned trying to get anything further.
The two being excited utterance, which we agree wasn't established, and the second one being state of mind, Mr. Hungerford's state of mind when he said it, and whose state of, I mean, Mr. Yes, go ahead. I don't want to put words
I
in
believe
your
Mr.
mouth.
Hungerford's state of mind at a later confrontation that he was present for And he expressed some concern about aggressive behavior that was being exhibited because it informed why he was concerned about that behavior, because he had knowledge of a prior incident, and that doesn't rely on that prior incident actually being there, but that he knew that Lee had stated he had some type of beef with these individuals. But again, the government doesn't rely on this. The information about the second interaction where there was aggressive behavior is not at issue here. So there was no problem with that. We didn't even use that to argue motive, right?
So is
It
this-
would have properly been able to be used to argue the motive. We didn't. We simply relied in closing on.
So is the government saying, essentially conceding that it was erroneously admitted, this last statement, but it doesn't matter because it wasn't prejudicial because you didn't really rely on it?
Yes, our ultimate position is that there's no prejudice. We have a plainness argument as well, but I think the easiest way here home is that there was no prejudice on a plain error analysis. If there are no further questions,
All right, thank you.
thank you.
All right, Mr. Atkins, or Akins, excuse me.
Thank you, Your Honor. I think I have, by my count, 4 points I'd like to make in rebuttal, and I'll try to keep them quick. I'll start right where we left off. I don't want to get into the quibbles about the record or the hearsay exception. What I'll say is, I think what we just heard the government say is that this was hearsay, that they probably knew it was hearsay, and they hadn't laid an adequate foundation for any of the exceptions that they applied, and there was nothing from trial counsel. So again, speaking of the trial record speaking for itself in terms of trial counsel's performance, I think this is a poster child example. I'll then turn quickly to something we didn't address in the opening, which was the 2 jail calls. The call from Minor to Culver's girlfriend, I think you're exactly right that the person he could have been talking about that only knew that information is Blakey. The government has conceded that he spoke to Blakey. Wouldn't have taken long to convey this story. That explains that jail call. The other one about the jail call with his girlfriend, Tweety Liggins, is her name in the record. There was testimony at trial that people in this community, in this neighborhood, understood that if you cooperate with the police, that there was a risk of violence. It is perfectly plausible that that Minor was concerned that his loved one would be subject to violence if she cooperated with the police. This court was very clear in the Williams case cited in our brief that these kinds of interactions that maybe show consciousness of guilt are often explainable with an innocent explanation as well. We are not here on a sufficiency of the evidence claim where you have to take every reasonable inference in favor of the government. An equally plausible explanation is an innocent one. I'd like to then turn back to the 23-110 issue, and I have a few points that I'd like to group into 2 buckets. The first is some of the kind of scientific points that my friend on the other side talked about. My overarching point is a lot of that is what this court would call, fodder for cross-examination and not for admissibility. So for example, he explained that the study that was used on light and distance, that there was some dispute about whether the percentage of accuracy would go up or down based on whether you could see clothing. This court explained in the Butts case, again in the Lewis case, that scientific studies don't have to be one-to-one for what happens in the courtroom. If they were, we would never have any experts. If there are non-material differences that the expert can explain, that is not a ground for throwing out the opinion entirely. And here, Dr. Covera explained that the whole point is, if you can't see the person's face, you're going to have a less reliable identification.
So if we were to agree with you that the colloquy between the witness and the government at the 23-110 hearing really was one more appropriate to cross-examination after the expert was admitted, so it didn't go to admissibility, then that seems to me to put more pressure on the other way of showing deficient counsel, deficiencies in counsel's performance, and more burden on you to show that counsel had not considered and rejected the idea of admitting an expert, and that's not really shown on this record.
I understand the government's point, and I take it, and I think this is the same point the Superior Court made, that essentially what they're saying is that the cross-examination would have been so devastating that no trial counsel worth his salt would have thought about calling this witness. 2 responses to that. The first is, As I read the record below, the cross at best would have been equivocal, right? They knocked things down and show that the expert, has nothing useful to say, which isn't to say that the expert has something bad to say. And it's not like, trial counsel was choosing between this expert or that expert or this alibi witness or that person. There were no defense witnesses. He's not taking up trial time with some other witness by calling this one. So it wasn't a choice of resources thing. So I don't see any downside to calling
But we
someone.
don't know, we do know that no lay witnesses were called by defense counsel. But we don't know whether defense counsel considered calling expert witness and rejected it or not. That's the question.
I don't think we know that with certainty. I think, again, we can use the circumstantial evidence of performance at trial to inform that question. My point is a little different. This court recognized in the Kigosi case, I believe it's at page 654, it might be 52. There was some dispute about whether trial counsel had or had not investigated calling an expert witness on the effects of PCP on kind of brain function. And the court said, even if the trial counsel had explored, there was no good reason not to go on and call the expert. And so that was still deficient. I urge you to look at that case. We're in the exact same situation here. And then again, this is in Kigosi. It's also in the Richardson case that we cite in our brief, pages 496 through 500, where the court explains where there's no downside, there's no cost of going that extra step. No reasonable counsel would forego it. And we believe that that's the situation that we're in here.
Can I ask a question, procedural one? And I hate to interrupt you, but wasn't there, when we're looking at this, what should we make of the fact that, and maybe the appellant wasn't asked this in the trial court, and I'm confused, but was a material witness subpoena offered by the trial court to appellant to bring counsel to the hearing?
It was, Your Honor.
And what are we to, given the burden and the responsibility, the burden on the appellant here, given the outcome of that 23-110 hearing, what are we to do with that? What are we to make of that? Because that would have, of course, provided what the chief has suggested was missing in terms of having that basis. So how do we weigh that in this evaluation?
Certainly, Judge Washington. What I can say is that, in our 23-110 hearing, this is not in the record, but I can represent to you, in our 23-110 investigation, we too tried to reach out to Mr. Nichols, and like the government, we're basically told, I want no part in this, go away. And at the time that the material witness warrant is offered, we now have seen Mr. Nichols lying to the United States Marshals about being Mr. Nichols. And so we, I think, understandably have some hesitance about calling in a hostile witness who has proven that he's willing to lie to the U.S. Marshals about his identity to avoid having to testify in this case, that we have to then call that witness to the stand where there's nothing in the defense file that we could use to impeach his testimony. But basically, we're in a really tough spot. And ultimately, we decide this court has never said that you cannot rely on circumstantial evidence to prove deficiency. In fact, it said the opposite, that you can. We've seen the Supreme Court find trial counsel ineffective in cases where he didn't testify. So we decided that in that situation, the best position for the court was to rely on the record as we had it, and essentially that Mr. Nichols simply wouldn't help the court's truth-finding function. The last point that I'd like to make very briefly, there was a lot of talk about the state of the court's cases at the time of trial, about the 2021 Parker case, about the Heath case. I think the key distinction there is exactly what Dr. Covera did in this case, which is to bridge the gap between stranger identification cases and familiar identification cases. As I read Heath and I read Parker, going all the way back to Hager, those are cases where the expert didn't explain why stranger identification studies are useful in familiar identification cases. Dr. Covera did that here. I'll point you to a few places in the record. The first is page 66. These are all of the evidentiary hearing transcript, where she says it doesn't help to be a familiar other if you just have conditions of low lighting. She goes on to say, page 75, stress interferes with the ability to process the information as you're receiving it. That would be true whether you're familiar or whether you're a stranger. Weapon focus or an implied weapon focus draws attention away from the face. That's on page 80. Again, that's true whether you are a familiar person or a stranger. She then goes on, this is particularly helpful on page 87 to explain why jurors think that, quote, low levels of familiarity are very helpful when, quote, our research suggests that you need many, many more encounters with a person before they become familiar.
Do you reconcile that with Mr. McGovern's point that I think she said, or somewhere it said that the brain processes are completely different in these two different situations?
I think they're taking those studies out of context. Those studies are about extremely familiar people. They're talking, they're putting pictures of Bill Clinton on a page and saying, do you recognize this person? Of Brad Pitt, right? Famous people that we've seen over and over and over again. I don't think we're nearly that close to the spectrum of familiarity in this case. Hungerford testified that he knew
Aren't
Minor from around the
we
neighborhood.
more
He would,
familiar?
excuse me?
Aren't we more, arguably in more familiar territory? In the community of Barry Farms where these folks grew up from childhood, it's a pretty contained area. They know each other, see each other around since, I think the testimony was since they were children, so that's at least a decade.
That's true, but it's not like they were friends. I mean, I think at best they were acquaintances. What Hungerford testified was that they would, quote, see each other around the neighborhood, and they would, quote, say hi and bye, and that's it. We also know that Hungerford, although they both grew up in Berry Farms, Hungerford did not go to school with Mr. Minor. In his, he admits that in his interview with the police. That's Exhibit 303A from the trial court. He went to high school at Dunbar High School, which I think the Berry Farms residents, jury of DC residents would know is not in Berry Farms, it's quite very far away. And also that up until 2 years before the shooting, Hungerford had been living in California. So this is not someone that he's even really seen that recently. So I don't think we're in the stage where, it's like me identifying my mother or me identifying Tom Hanks. These are people that are really at best acquaintances, and that puts them in the kind of casually familiar category that Dr. Caveira's, the studies that she relied on, Pesdak and DeJong were relying on. If the court has no further questions, we would ask that you reverse the denial of Mr. Minor's 23-110 motion.
Great, thank you. I'd like to thank counsel, Mr. McGovern for the government and Mr. Akins for Sidley and Austin, and also like to express the court's appreciation for you taking this matter on pro bono today. Thank you.
Thank you.
Right, our second and final case today is Henry James Allen versus Byron Lee Kidd. Great, counsel, are you ready to proceed? And just for the record, I would note, Mr. Kidd, you're representing yourself. You're not represented by counsel today. Typically, each side gets 15 minutes, although as you've seen, the court is pretty liberal in construing that 15 minutes. Mr. Gowan or Gowan?
Gowan, thank you. Thank you, Your Honor.
I'm sorry, I just wanted to mention one other thing to Mr. Kidd, just so we're all clear on the process here. That the appellants also can reserve time for rebuttal, appellee cannot.
Yes, I would like to reserve 3 minutes for rebuttal. Good morning, good afternoon. I'm sure the court's excited to get to apply Texas law to a situation where there's very little case law on point here. But, I want to first start with our capacity issue. The trial court is equating the capacity issue with retroactivity of Obergefell. I don't think those are synonymous, and I'll explain why. The issue of capacity is whether or not two people could agree to be married at a time when that was illegal. This is a situation where, they couldn't get divorced in 2 or 3 years if they decided they didn't want to be married. They couldn't be married. And I think, the retroactivity would apply to a situation where a party, a couple was legally married, let's say in Massachusetts, and then wanted a state that didn't recognize legal marriage until the Obergefell opinion, that would be a retroactive application that would be fair and make sense. But here, this is a situation where neither of them, they couldn't be married under Texas law. So how we can say that they could reach an agreement?
Counsel, can I interrupt you there? Isn't this case exactly about Obergefell's retroactivity and capacity? You said it's not about that, but isn't it about that? When we say that Obergefell's effect was retroactive, essentially meaning that any barriers to the capacity of parties in same-sex marriages to be married were retroactively alleviated. So then we would look at, well, I'll stop there.
Sure, no, I appreciate the question. I think this case is it's an analysis on prong one of the elements for common law marriage in Texas and prong three. Prong one is an agreement to be married. Again, you're entering into a contract where you sort of knowingly doing that. You can't appreciate the risk or benefits of that because you couldn't experience the risk or benefits of it. As I said, they couldn't get divorced, and they could also marry anybody else they wanted to in 2 or 3 years without that being in conflict. So I think it's hard to say that the retroactivity would apply in a situation like this. The trial court cited the Gill case from DC over 11 times, I think, and saying that the language there of the first prong of the common law marriage statute in DC is substantially similar to that in Texas. I argue that it's not. I think the statute in Texas is more stringent, especially after that 1989 amendment. But also, Gill did not find a common law marriage. I mean, if you read the court's opinion, you would think Gill found for a common law marriage. Gill set an unbelievably high bar to prove common law marriage in DC. But again, we're talking about Texas law, not DC law. And arguably, I think that first prong of an agreement to be married is more stringent than the first prong in DC.
Is your argument that we really, until there's a decision of the Texas Supreme Court or whatever, we really can't, decide this question? Are you saying that, DC courts can't just sort of take their best shot at interpreting the Texas law? I take your point about applying our own case law, interpreting our own statute. Maybe, doing that really strictly might not be the right way to go, but we can can't we use our own tools of interpretation? And certainly there are some decisions out there, right? Unpublished decisions and federal court decisions. Do we really need to wait for the Texas Supreme Court to decide this once and for all?
I mean, you're all much more qualified to answer that question than I am, but the conflict of law sort of question. But the case law that's out there from the unpublished opinions, I mean, there's no case that's on point. There's no case where a Texas court found that a common law marriage that was entered into prior to Obergefell was found to be substantiated under Texas law. So I do think that, I mean.
Well, do we have to match the facts so exactly? What about the Smalls case in Texas? I think it was, I don't know whether it was the Intermediate Appellate Court or the Supreme Court, where you had a relationship that was secretive, an affair. And the question was whether they could establish an intent to be married in that case. And ultimately, the court found that they had established sufficient facts that they intended to be married, that they were holding themselves out as being married. And the court found that that was sufficient for a common law marriage. Isn't there an analogy to the situation here, that even though they may not have lawfully been able to marry at the time in a same-sex union, they were intending and holding themselves out as intending to be married.
I mean, I don't believe so. I don't believe the Smalls case is analogous because it's not a same-sex couple there. So that there they could have they could have gotten divorced. They could have gotten, they could not have remarried someone else once they've established this common law marriage. Obviously, common law marriage in itself is a very tricky situation here. It's very hard to understand. And so I really think that the best approach, I mean, one, to your Honor's point, I do think some guidance from the Texas legislature is long overdue, or the Texas Supreme Court here, because, I mean, their statute even still uses man and a woman, husband and
But why
wife
do we need
on there.
that?
But
With the Supreme Court case in Obergefell and many other Supreme Court cases that say decisions from the highest court in the land are deemed to have retroactive effect to avoid situations like this one, arguably.
And like I said, I see the retroactivity applying to a situation where a couple legally married in one state and then tried to enforce that marriage in a state where they couldn't be legally married. And that the retroactivity would say, yeah, you've got to recognize that marriage. Because here it's just sort of a logical analysis under prong one. And it's why, you know, the circumstantial evidence that the court relies on, the cards and the rings, but sort of ignores the other circumstantial evidence, which is that, you know, what would have really shown an intent to get married is that when they legally could have married, which was as early as 2004 in Massachusetts, where they visited often, 2010 here in DC, 2015 everywhere, they didn't choose to do that. And when asked about, well, why we didn't do it, you know, the plaintiff said that we just couldn't, my family, we couldn't settle on a date. Whereas the defendant's testimony was very clear. We met on the steps of the Supreme Court the day Obergefell came out and he said, should we do this? And he said, no, I just don't think we need to be married. I don't want to, that's not me. And so I think there's a credibility issue and sort of ignoring that massive fact that why wouldn't you have gotten this or registered it under Texas law if you really believed you were married? And then secondly, the fact that neither of them were aware of what common law marriage was, knew of the phrase, had ever used that phrase before. Again, the trial court says it doesn't matter how people characterize their marriage as either common law marriage or not common law marriage to other people. That's not the issue. I agree with the trial court on that. The issue is, how could two people have entered into a common law marriage if you didn't know what a common law marriage was? And that's a big problem, I think, under
Common law marriage is, I'm sorry, because you said, first of all, with respect to your retroactivity argument, it sounded like a comedy argument. Basically, now that Obergefell's been passed, you have to accept what a marriage in Massachusetts in Texas. That's a little bit different than the idea that it applies retroactively to their relationship, which most people don't enter into. That's the whole idea, a common law marriage. It is deemed to be a common law marriage more likely than not because of the relationships they have. And here you seem to be arguing that the trial court erred in weighing the evidence, which we would not, of course, under these circumstances, unless you were claiming there was insufficient evidence, engage in that activity. So for us, the trial court has made specific findings to support its findings under the three factors under Texas law for establishing common law marriage or informal marriage in Texas. And the question for us is whether, in fact, those elements were met, assuming Obergefell is applied retroactively, which we and you don't seem to be taking exception to. And had there been marriage allowed, if the statute had respected the constitutional rights of the parties, right, back when they did engage in these conduct, would they have been considered married? under Texas law. And so to point out that Texas law is antiquated and doesn't comply with Oberfeld doesn't help us decide the case. And when you're looking at, I'm looking specifically at your appeal, and in your appeal, your first issue is whether there's evidence to support the trial court's finding that the factor one, that they had actually agreed to be married, was satisfied. And the trial court and even Texas courts say you can look at other factors under common law marriage, their cases. You can look at factors in that would satisfy 2 and 3 to determine whether in fact factor one has been satisfied. The trial court does that. The trial court does talk about the exchange of rings, but the trial court also goes further, and the trial court talks about the way they interacted in Texas and how that in fact informed her decision as to whether they satisfied factor one. And so if that's the argument, the trial court erroneously found element one, I'm trying to figure out what it is that we're here to discuss.
No, this is definitely not it looks like a duck analysis here. This is, under prong one, and then I'd really like to move to prong three because I think that's far more simpler to address. But I think under prong one, our argument is that it's just impossible to say that two people could have agreed to be married when they couldn't have been, and there was no consequences to that decision. That's
a legal question.
Yeah.
And Oberfeld doesn't solve that legal question for you because why?
Because I don't think it's a situation where you're saying there was an agreement to be married when you couldn't do that, when the benefits and consequences of that agreement wouldn't be experienced.
Let me ask you this question. We take a circumstance where someone with great means engages in similar conduct, doesn't think they're common law married either, and then and lose half their estate to in a divorce proceeding later on. They didn't contemplate the consequences of what they did not understand to be a marriage, right? But the evidence supported that it was. Why is that different? Why is it important that the fact that they could have gotten divorced shape the determination as to whether they are actually married?
Because, I mean, so you're saying in your situation, the wealthy person, they exchanged rings, they told people, they called each other husband and wife, and that's it. So in that situation, they're on notice that there are consequences to that decision. There's common law marriage, and you've said, will you marry me? You put rings on each other. Now there's consequences to that. And if you decide you want to get divorced, you can get divorced. If you can't remarry someone, whereas that just wasn't the case for them. But I would like to move on to that third prong, because I think that's a far simpler question, and maybe that first prong does come down to we need more guidance from Texas. But the third prong is very simple here, right? I mean, they have to hold themselves out in the state of Texas as a married couple. And
what is your authority for that bright line? That it's the state of Texas as opposed to in their community, the relevant community, or something broader?
The statute and all the cases, it says, and there, so they lived as a couple, as a married couple in Texas, and there represented to others that they were married. And there's the case law, it says reputation in community. These are the types of things. There's no case that suggests that you can prove that you can meet this holding out
Wouldn't it
requirement.
Be context specific, like if a couple of spies, moved to Austin, Texas or whatever, and they don't have a community there because they're trying to keep a low profile and no one knows who they are, and their families, the evidence that comes in is evidence about the community they do have, which is their families and their friends in other cities or whatever. Is that just that they would fail prong three?
I think and this is just the language of the Texas law, they have to show in Texas that they have to hold themselves out as a
It's the
married
word
couple in
there
Texas. It's a
that you're-
protection too. It's for people making false claims.
It's the word there that you're relying on.
Yes, yes.
Ask a question though about getting to prong three. Um, uh, Why doesn't sort of the prescription against the exercise of constitutional rights that are retroactive being discounted or being frankly found to be an unreasonable burden on the exercise of constitutional rights, addressing that issue? Yes. Even if I agree with your interpretation that it has to be in Texas, if in fact, as you know, Texas didn't recognize and frankly was may have been hostile to these kinds of relationships, and if now, and so the burden of holding yourself out in Texas would have perhaps ended up being very detrimental to you, which is a burden on the exercise of a constitutional right, which they have, which is applied retroactively. Why isn't our role in looking at that, understanding what the Supreme Court is saying and understanding the burden that might, the unreasonable burden that would place on a same-sex couple, take that into consideration and as an unreasonable burden on the exercise of their constitutional rights?
I mean, so there's sort of three parts to that answer. The first part is the statute is the statute. And it requires a holding out for good reason, because we don't want people to just make up and say they were married. And so you have to show that you really represented yourselves in the community. And it is a situation where this is legal in Texas, but it's not legal in Oklahoma or Louisiana or the other states that border Texas. And you know, it's only legal in 9 states in America. So there's a reason why.
But there are same-sex couples in, I would venture to say, far more than 9 states in this country. And they are living together, holding themselves out as married in some instances, and representing that to the communities that they move in, whether or not it's legal in those jurisdictions. And I think that preceded Obergefell. And here the trial judge found some factual circumstances that supported, in the trial court's view, a holding out. The photographs that are in the record of the appellant and appellee wearing wedding rings together, and that same photograph being used as a holiday card, clearly labeled as, I believe, Dallas, Texas. Telling coworkers. So there were factual findings made by the trial judge here.
And if I can address those, because I think that's crucial. Because so the only factual finding, and the court acknowledges that the record is not robust on this issue. The only factual findings by the court were this card. The card doesn't show that it was sent to anyone in Texas. There's no testimony from anyone that that this couple held themselves out as married in Texas. Not one ounce of testimony on that. The only testimony about telling anyone in Texas came from the plaintiff, and this was completely contradictory to his discovery response. And this, I think, is so crucial here because it's unbelievably prejudicial and unfair to the defendant. We asked, state the names of the people and give us their contact information that you told in Texas that you told about your marriage. And he said, we were, at that time, we lived in Texas wasn't in a friendly environment. The environment was not friendly, so we kept the marriage to ourselves. And then about a year later, in discovery, supplemented that answer and gave his aunt's name with her phone number, who does not live in Texas. So we go to trial, we review, we consider settlement. We're all of this stuff preparing, knowing that they don't have a witness, that we can bank on this, that they don't have a single person who they could say they told that they were married in Texas. There's nobody from the community in Texas that can say, yes, they held themselves out as married. I understood them to be married. So that's a huge part of our analysis. And then for then at trial to come up with these two names of work people that they told, that's unbelievably prejudicial to the defendant, because if we had known that these two people, then I would have subpoenaed them. I would have, I would have been able to cross-examine them.
Did you ask the trial court for a continuance to do that?
Yes, I did. I mean, we objected. I laid my record. I think I laid my record sufficiently on that. And the court said that you can impeach on that matter. And so, that's all we were allowed to do. But that's unbelievably prejudicial. That's the only evidence toward that element is that they told Pat and Angie.
Can you, I'm sorry, where in the record? Do you lay that foundation or that to make that argument? If you when you're sitting, you don't have to do it right now, but while Mr. Kidd is presenting,
Sure.
if you find it, I appreciate it. Okay.
And so, that reputation in the community, this is the language that the courts use. The Campos case talks about status in the community, general reputation, a public and open holding out, taking the other person's last name. This sort of analysis this court did in Gill would apply here as well, even though the law is different. I mean, I just don't see how they held themselves out and how this court could have found that they held themselves out to the community in Texas when the only evidence is that they said they told two people. And so basically the court.
Your argument, I'm sorry, so you didn't raise on appeal, the trial court abused its discretion in not granting you a continuance when you were surprised at the trial. That's not before us. So you are really, in essence, arguing that whatever was done in Texas, even assuming for the sake of argument that two people were told, that's not enough. That's your argument on 3.
Right. Especially since they didn't testify, that this is only from there. But I did object. We did move to strike the testimony. And I would submit that's sufficient.
But did you raise in your brief?
Yes.
I mean, as a separate, I know that this is one of the problems I was having. There's a lot of arguments seemingly embedded in portions of your in portions of your brief, but it's not set out, as I understand it, as a separate challenge to the trial court's ruling. It's sort of built into the argument that they didn't hold themselves out, right?
I believe it's the third prong where we raised a discovery violation. This is.
I understand that. Okay, I thought it was set out separately, but what you're saying is it is, and I acknowledge it is part of the conversation around your third prong.
Right, and so what the trial court created 2 exceptions to prong 3. The exception 1 is that Texas is hostile. That in 2001 Texas was hostile towards same-sex relationships. Well, that's not an exception that's recognized anywhere in the law.
Why doesn't it make sense just when you're, she's analyzing the facts to have a lower bar when you're talking about the reasonableness of, assessing a couple holding themselves out? Why doesn't it make sense to have a lower bar for a gay couple living in Texas?
For a couple of reasons. One is it's not the law. There is no exception to the law that says you can do that. And 2, there was no testimony or other than the plaintiff saying so that Texas was hostile. So it's just like we're up here in DC, we know Texas is a certain way, so we can just say that. Well, no, go to Austin. Go, that's just not fair, I think. And so there's no testimony put on for that, and it's just not the law. And then then her second exception that she raises is that they didn't have an opportunity to establish a relationship in the community because they left Texas shortly after. Again, that's not an exception that's recognized in the law. The fact, it's like if two people, are flying to the West Coast and they land in Dallas, you change over, they say, hey, let's get married. Okay. And then they're off and they tell one person at the Chick-fil-A, like, that's not, I don't think
Well,
we would all
here,
agree that doesn't count.
The
Like,
facts are a little different here, that they were in Texas and they lived together in Texas for a period of time, maybe not as long as they lived in other places. And the trial court does credit some of the testimony below as supporting the three elements under the Texas law, and that the trial judge recognizes that the Texas statute is different from the district's statute. Um, I have another question that you may not be able to answer. It's unrelated in some ways, but this trial was bifurcated. So the trial judge wanted to first look at the legal question of whether there was a common law marriage, and then once she concluded that there was, she went on to look at the things that you would typically look at when you're dissolving a marriage. And there was no challenge to the dissolution, not to the dissolution, to the division of property or assets or anything. Is that correct?
No, we're not appealing the court's findings, and neither is the plaintiff regarding the equitable distribution of property.
Okay, because I was just struggling to, I mean, usually it would be the reverse, that the challenge to the validity of the marriage would be a precursor to challenging the division of the assets. And since there's no challenge to the division of the assets here, I guess I was just curious why we're challenging the validity of the marriage. But like I said, it's an
Yeah, no,
unfair question. You don't have
No,
to answer.
I thought it made a ton of sense. I think all counsel, opposing counsel, I all thought it made sense. Let's first, this issue of whether there's a marriage, this isn't a simple issue. It's not a layout, so let's litigate that first. Then we moved, after that was decided by the court, we did move for an interlocutory appeal. This court denied that. So then we had to go forward with the equitable distribution. We don't take any issue with the equitable distribution that the court did. I mean, it was reasonable and fine. So the issue is just the finding of the marriage.
The finding of the marriage, if we were to find that the trial court erred and reversed, then what happens to the equitable distribution?
That order is just nullified, that, nothing's been exchanged, nothing's happened yet. So that would be pretty simple to handle. It would just be.
So essentially, both parties kept what they had, and there was not a.
Right. That would be how this rules. So, this, and again, just to the first point Your Honor was making, we're not challenging the second prong that they lived in Texas. They did live in Texas, but we're challenging the first and the third, and the third very strenuously here, that, these two exceptions, that Texas was hostile and that they didn't have enough opportunity to establish a community, that's just not part of the law. And this is
Why aren't those exceptions really more like circumstantial or contextual, factual parameters, that the judge is looking at the situation as it is, who these people are, how long they were there, in order to decide what it means to hold themselves out?
I mean, I would direct Your Honors to the Russell case, and then this amendment that the Texas legislature made in 1989, where they said this common law marriage language we have needs to be beefed up a little bit. We need to make this a little more stringent. And so they added this reputation in the community. I think it's because we don't want people just taking advantage of the law in Texas. So there has to be, this common law marriage thing. There's got to be some factors and elements on this. And so, you just can't, and because it's not legal in other states, it had to occur in Texas. And so I think the court's analysis in Russell over what that 1989 amendment meant, and the amendment itself shows that the legislature very much is intending to make the conditions more stringent. And they're just these two exceptions that Judge Becker created aren't the law. And so I think that's a problem. I think that the discovery violation is blatant and really prejudicial to us. And then lastly, we have this Florida issue, just to further complicate things for you. You know, 4 years later, they go to Florida and sign an affidavit that they're not married and become domestic relations partners, taking advantage of the benefits of that. So we're basically saying, I'm going to take advantage of the benefits of married over here. I'm also going to take the benefits of domestic relations over
Clean
here.
hands,
Yeah,
clean hands argument.
yes,
Uh,
and it's like you can't do both, right? I mean, and so if a couple was common law married in DC legitimately and then went to Florida to apply for domestic relief, that would be invalidated because they were married. You know, here they didn't really think they were married because they wouldn't apply. I mean, they swore under oath that they weren't married to apply for that. And so, I mean, that just has to mean something here.
Because I just want to understand actually your arguments. Your argument is whether Oberfeld applies or not is irrelevant to the determination here. Assuming that it is retroactive, as we've said, then you look at the elements and it's where it says man and woman, you substitute out and say, no, that is what is illegal. That is what is unconstitutional to limit it to a man and woman. And that's it. Everything else in order to establish common law marriage is the same. And there's just no evidence to support the prongs, even if, even assuming that they were a man or woman, this would not be a common law marriage in the state of Texas.
For the most part, yes. And then also that this discovery about that the only evidence put toward prong 3 was a discovery violation, at least in that they didn't, when asked that question in an interrogatory, didn't mention these two people. And so it just it just comes out at trial. I think that is a big problem. The trial court, at the end of the day, like this opinion is just a credibility opinion, right? It's not, I think they're fine. She's finding
The opinion, what on appeal would you be asking us to do? To find that her credibility determinations and factual findings were clearly erroneous?
no, the credibility determinations are irrelevant because it's the law. They didn't meet prongs 1 and prongs 3, couldn't meet prong 1. And prong 3 is there's just absolutely no evidence, not 1 ounce of testimony or document submitted that shows a holding out in Texas as a married couple. And so this really comes down
I guess
to
just looking at the
the law.
trial judge's order, on prong 3, she does find that she references a USAA page that identifies Mr. Allen as a family member. She mentions, she references the telling of the 2 coworkers and wearing rings. And she also references the anniversary that they reference to their relatives. So she makes some findings. I'm just reading briefly from some portions of the order. So you would be asking us to conclude that those findings are clearly erroneous.
Or insufficient.
Yes.
Okay.
But
Which one? Is it clear? Are they clearly erroneous, not based on evidence in the record? Or are they just insufficient, even if you credit the evidence in the record?
They're insufficient because the only evidence that Your Honor just of what you just recited, the only evidence that is connected to in Texas is the telling of Pat and Angie, the coworkers, which when asked that exact question on an interrogatory, we were not given those names. And so that is insufficient. The other stuff doesn't connect to Texas. So you could say that those other pieces of evidence are relevant to prong 1 for sure. I agree with that, but they're not relevant to prong 3, the in Texas requirement. And then with respect to prong, the first prong again is, I mean, the court said that in her own opinion, as she's concluding that the common law marriage is something for people that can legally marry but choose not to. Right? But this is not but that like right there tells you that's not what this is. They couldn't have been legally married. So that's not what we have here. And that's bolstered by the fact that they signed an affidavit that they weren't married in Florida afterwards. And so I think every time common law marriage comes into play, it's hard to say what to do here. I mean, kind of like the first case, you just don't know what really happened. But the law is, you have two people saying different things. So it has to come down to these elements have to matter. And it can't just be, well, I believe, I look at all those pictures and so I believe him. Like, no, you have to meet these elements because you're talking about establishing a significant contractual relationship that has, benefits and consequences to it. And so these elements are there for a reason and they have to be followed and they're just not here. They can't be under prong one. And under prong three, there's just no question that there is no evidence of in Texas. And I'll reserve.
All right, well, we'll reserve the remainder of your time for
Okay.
rebuttal. Thank
Thank
you.
May it please the court. My name is Brian Kidd. I'm the appellee in this case, and I'm appearing on my own behalf. This appeal asks the court to overturn factual findings that the trial court made after hearing testimony and reviewing the evidence. The trial court applied Texas law that governs informal or common law marriage. Under the law, the court must determine whether three elements are satisfied: an agreement to be married, living together in Texas as a couple, and representing others that the couple is married. After hearing testimony and reviewing documents, the trial court found that those elements were satisfied. The court also made clear credibility findings. The court found that my testimony and my family's testimony credible. The court found that the appellant's testimony and his family's testimony were not credible. Those findings are supported by evidence in the record. That evidence includes written cards referring to the parties as married, testimony about living together in Texas, evidence that the parties exchanged and wore rings and referred to each other as husbands.
What
Because
about on the, Mr. Kidd, on the third prong of holding yourselves out in Texas while you were living in Texas as married?
Your Honor, the evidence includes the exchange and continuous wearing of rings. Coworkers
The
observed those
rings were
rings.
exchanged in Texas?
Yes, ma'am.
Mhm.
Coworkers observed those rings and the parties referred to one another as husbands.
Where did you, because it's not clear to me where you referred to each other as husbands.
In Texas.
No, more specifically than in Texas. Because I mean,
Dallas.
because you're on one hand saying we didn't because it was a hostile environment. And now on the other hand, you're saying, oh, we did, even though it was a hostile environment. So you can't have it both ways. Did you, if you held yourself out as being married in Texas, then we would be looking objectively at the evidence and determining whether it satisfies the requirements. But if you didn't, then that's a different question for us in terms of our review of the legal, whether you met your legal obligations.
We wore rings.
Okay,
Okay.
all right.
We exchanged rings and we did not go screaming down the street going, we're married.
No, but I lived in Texas. I for a number of years, well before this, when it was probably even more hostile. And yet there were communities of people, because they are everywhere, who were same-sex couples who were very, very open about their relationships with people they trusted. And so there's a part of me that is hesitant to accept that just because Texas has a statute that clearly is antithetical to the idea of same-sex couples, that it was enough just to wear rings as holding out. And so that's why I'm asking. And it goes to this third point, this point counsel raised, which, as I said, is not sort of the trial court erred in not granting me this request, but is more into this third argument of the holding out. What was submitted on behalf by these two individuals, the trial court credited with having knowledge of your relationship, assuming, even if we assume that two people were going to be enough to hold out in Texas? Were there affidavits? Was anything submitted other than you testifying they knew?
Your Honor, the record includes 126 written cards and notes and that were signed and dated by the appellant over many years. In those writings, he repeatedly referred to us as married and called me husband. The trial court considered those written statements together with his testimony represented at the trial and concluded that they showed an agreement to be married.
I'll look back at the court's order.
After hearing the witnesses and evaluating credibility, the court found the agreement element under Texas informal marriage law was satisfied.
Are the coworkers you referred to, is that Pat and Angie?
We were in a rather non-accepting environment, working for a company that was very anti-accepting, if you will. I mean, we were contractors. You had to be very careful what you said because at the level at which we were working, we did not want to be ousted just because of who we were or what we were doing. So we kept it, we let them know because they were key folks that we knew that would understand. We were working 80-hour work weeks as well. We were not participating in the community out. It was work and go home.
The appellant argues that he didn't have a chance to rebut that evidence of the Pat and Angie knowing, part of the prong 3 analysis. What's your response to that?
I don't have, my only response is that the trial court heard the witnesses, evaluated the credibility, and made findings supported by the record.
Trial court believed you. In essence, the trial court believed you. Okay.
If I may continue my opening, just to finish off, the findings are supported by the evidence in the record. That evidence includes written cards referring to the parties as married, testimony about living together in Texas, and evidence that the parties exchanged and wore rings and referred to each other as husbands. Because the appellant's arguments asked the court to reconsider those factual findings and the credibility determinations, the judgment of the trial court should be affirmed.
Were you represented by counsel at the trial court?
Yes, ma'am.
All right. Was there any further questions? Thank you.
Thank you. The exchange between the court and I over the discovery violation and the objection to movement and strike, that starts on page 101. It goes on for about 3 or 4 pages there. And so and like I said, the court just says you can impeach on that. And I don't believe that was fair.
But does the court have discretion to decide how to deal with that problem? Is allowing impeachment sometimes reasonable, or you're saying she really had to strike the evidence?
In this situation, when you're asked, like, I mean, this is so prejudicial. The only evidence that goes to this third prong of holding out in Texas was these two people's names. We asked who you told and didn't give us those names, and then at trial says those names. I don't think that just impeachment alone is on that. I can't even question these witnesses, like, did he actually tell you that, right? So like, I don't even get to ask that question. Not a single witness testified that, yeah, they told me they were married in Texas. Nothing, right?
But did you, I keep asking you this question, and I apologize, I will look at the transcript. I just want to hear from you. Did you say to the trial court, we need an extension of time? Or did you just say, strike it? And the trial court said no? Because I think it's two different requests for relief, very different.
I appreciate that. Maybe I did not ask for the continuance. I think that my objection, I do know a lot of this was at the bench, and some of the transcripts off on that, but there's no question that we objected, moved to strike. We raised this as a discovery violation. I think that would have been the proper resolution in that situation.
And review it on that basis, that it was you're arguing that the trial court abused its discretion in not striking this evidence under the circumstances.
And then misweighed it as well. Like, I mean, that if that's it and there's no cross-exam allowed or testimony to that, that really doesn't meet the standard here. And then one other point that, the court keeps relying on these cards and notes between the two of them, but also relies on Gill tremendously in this case, where she says that the first prong of an agreement to marry in Texas is substantially similar to the first prong in DC, and then Gill is cited. But here, the facts are almost identical to Gill. I was the plaintiff's counsel on Gill. In Gill, we had rings exchanged in a bowl of M&Ms that said, will you marry me? And he brought the bowl of M&Ms in there. We had documents after documents sworn under oath, emails, cards, all of that. But what the court was so held up on was there was never an announcement. He never announced on the day. And here we have that again. The day they were married, not a single email, not a text message, nothing to anyone. I just got married. Not any time in the whole month was there a single communication that, hey, we just got married.
What do you make of the cards? I mean, the cards exchange refer to husband, and they're dated so that some of the dates, I believe, correspond to the time that they lived together in Texas. Why does there have to be some declaration at the moment if they've exchanged rings, or they've been wearing rings? There's an exchange of cards. I'm just trying to recount. I can't recount it all off the top of my head, but the other evidence that was before the trial judge. Are we to discount the cards where there are declarations and exchanges of identifying each other as husbands?
I mean, that's precisely what this court did in Gill. It's exactly what this court did. We're ignoring the cards because there has to be this moment where the parties say, okay, we'll be married. That's the law.
Well, there was testimony that there was that moment, that there was a private exchange of vows between the two of them where they exchanged rings. So why wasn't that sufficient?
Again, it's the same reason it wasn't sufficient in Gill. In Gill, they even had the M&Ms that said, will you marry me? That was put into evidence. that wasn't enough because they didn't announce that they were married. They didn't tell anyone. And so here, again, no reference at all that, hey, Henry and I just got married in August. So if it matter, if we're saying that one, the element in Texas, which I would argue is more stringent, the first element is more stringent than the DC first element. If we're saying though that they're substantially similar, which the court says, and then cites the Gill case, which is almost identical facts, how you can't find that this was an agreement to be married. And I think that's the problem here. We could say that Obergefell's retroactive. I don't think the court, I mean, there really hasn't been an opinion that looks at the common law marriage side of that from a pre-Obergefell standpoint. And so, but again, you know, these cards, you can call somebody husband, you can call a person you're dating. You know, my son he's 7, he just got married yesterday. You know, they can call people those things, but it doesn't mean you're married, right? You have to meet these elements. So, and they're just not met here. And you know, that was part of the legislature's intent in 1989 when they strengthened the language of the statute. And so I think, you know, I just don't think this meets the law here.
Can I ask a question?
Please.
What exactly was the testimony by the parties below as to what happened at that ring exchange? I mean, are you characterizing it as this was a exchange of rings with with exhibiting or just demonstrating an intent to be married? Is that how Mr. Kidd portrayed that exchange of rings?
So I'll give you both sides of it. So Mr. Kidd says that he ordered he wanted to wear rings. He ordered these rings. They got shipped to their office. When they got there, they met in the break room and said, will you marry me? Okay. And they put rings on. Whereas Mr. Allen's testimony was he was in the military and didn't want people thinking he was gay at their employment. So he proposed wearing a ring to make it look like he was married, and because you could only be married to a woman at that time. And so that was the conflicting testimony. There's no testimony from either side that anybody said to somebody, we just got married. We didn't tell a single person. There's no holding out in Texas or anywhere, not just in Texas, but nowhere was there holding out. And that's a
time until, but those subsequent postcards and things,
none of them say we're married. They just show them they're wearing rings, but they don't say we got married. There's nothing in writing that says we just got married.
Well, the use of the word husband implies marriage.
To each other, but not to others. And it's just that holding out. There's no testimony that he called me husband, you know, that there's any document saying this is my husband. And so, and definitely there's no testimony for Texas. I think that's
Is Mr. Gowan still in the military?
I'm Mr. Gowan, never been.
Sorry, not Mr. Gowan. Sorry.
He just retired, actually. Yeah. Yeah, and that's a significant factor here. But he just retired from the Air Force.
What's a significant factor?
I mean, it's not before the court, but part of the equitable distribution is the military pension stuff. So, but yeah, he just retired from the Air Force.
All right.
All right, thank you.
All right, thank you. We thank both counsel and parties for your arguments and briefs, and the case is taken under advisement. Thank you.